Section 20B, Individual Accountability. 20.9, Enforcing Standards. Enforcing military standards begins with individual accountability. There are some activities and behaviors that, while arguably not illegal, are not in alignment with maintaining good order and discipline. Understanding the restrictions and our responsibilities for adhering to Air Force standards will help prevent the need to reinforce these standards. 20.10 Commander's Authority and Responsibility. While preserving an airman's right of expression to the maximum extent possible, Air Force commanders have the inherent authority and responsibility to take action to ensure the mission is performed. This authority and responsibility includes placing lawful restriction on engaging in dissident and protest activities, writing, distributing, publishing, or posting any unauthorized material, frequenting establishments that have been designated as off-limits, participating in any activities of illegal discrimination or any activities that a commander finds to be detrimental to good order, discipline, or mission accomplishment, interfering with the Air Force mission or law and order, or presenting a clear danger to loyalty, discipline, or morale of members of the U.S. Armed Forces. 20.11 Public Statements. According to AFI 1-1 Air Force Standards, the issuance of public statements on official Air Force matters is the responsibility of cognizant unit or installation commanders and their public affairs representatives. Ensuring that official statements are properly worded and approved avoids statements that do not reflect official Air Force policy or that could be misleading to the public if taken out of context. To ensure Air Force official information is presented professionally, personnel should make certain it is accurate, prompt, and factual, is confined to their particular areas of expertise, avoids a hypothetical and speculative nature, accurately reflects Air Force policy, is presented simply and honestly, and complies with the spirit and letter of the Secretary of Defense's Principles for Public Information. For additional information, refer to AFI 35-101, Public Affairs, Responsibilities, and Management. As representatives of the service in both official and unofficial contact with the public, members have many opportunities to contribute to positive public opinion toward the Air Force. Each Air Force member is responsible for obtaining the necessary review and clearance, starting with public affairs, before releasing any proposed statement, text, or imagery to the public. This includes digital products being loaded on an unrestricted website. Members must ensure the information revealed, whether official or unofficial, is appropriate for release according to classification requirements in DoD Instruction 5200.01, Department of Defense Information Security Program and Protection of Sensitive Compartmented Information, and AFPD 16-14 Security Enterprise Governance. 20.12 Free exercise of religion and religious accommodation. Every airman has the right to individual expressions of sincerely held beliefs, to include conscience, moral principles, or religious beliefs, unless those expressions would have an adverse impact on military readiness, unit cohesion, good order, discipline, health and safety, or mission accomplishment. According to AFI 1-1 Air Force Standards, leaders at all levels must balance constitutional protections for their own free exercise of religion, including individual expressions of religious beliefs, and the constitutional prohibition against governmental establishment of religion. They must ensure their words and actions cannot reasonably be construed to be officially endorsing, disapproving, or extending preferential treatment for any faith, belief, or absence of belief. Airmen requesting religious accommodation must continue to comply with directives, instructions, and lawful orders until the request is approved. If the request is not approved, the decision must be based on the facts presented, must directly relate to the compelling government interest of military readiness, unit cohesion, good order, discipline, health, safety, or mission accomplishment, and must be by the least restrictive means necessary to avoid the adverse impact. 20.13 Political Activities. According to AFI 1-1 Air Force Standards, generally, as an individual, you enjoy the same rights and have the same responsibilities as other citizens. However, as a member of the U.S. Air Force, the manner in which you exercise your rights is limited in some cases. While on regular Air Force status, members are prohibited from engaging in certain political activities to maintain good order and discipline and to avoid conflicts of interest and the appearance of improper endorsement in political matters. While Air Force members do have the right and duty as American citizens to vote and voice opinions concerning political matters, we must be careful that personal opinions and activities are not directly or by implication represented as those of the Air Force. Examples of political activities that may be prohibited or associated with restrictions include political rallies, speaking engagements, contributions, endorsements, sponsorship, campaigns, and demonstrations. Before engaging in any political activities, be sure to review applicable Air Force instructions and guidance. AFI 51-508 Political Activities, Free Speech, and Freedom of Assembly of Air Force Personnel provides detailed information on what Air Force members may or may not be allowed to do regarding political activities. DoD Directive 1344.10 Political activities by members of the Armed Forces includes guidance on political activities for all U.S. Armed Forces. 20.14 Alcohol Abuse. Air Force policy recognizes that alcohol abuse negatively affects public behavior, duty performance, and physical and mental health. The Air Force provides comprehensive clinical assistance to eligible beneficiaries seeking help for an alcohol problem. According to AFI 1-1 Air Force Standards, Air Force policy is to prevent alcohol abuse and alcoholism among its personnel and dependents, to assist Air Force personnel in resolving alcohol-related problems, and to ensure humane management and administrative disposition of those who are unable or unwilling to be restored to full, effective functioning. All airmen are responsible for exercising good judgment in the use of alcohol. State and foreign country drinking age laws, including those in a deployed environment, must be obeyed both on and off duty. Use of alcohol must not adversely affect duty performance or conduct on or off duty, to include the ability to be recalled, if specifically required, when serving in an on-call status during scheduled off-duty time. Drunk driving. Alcohol abuse, such as driving while intoxicated, can lead to disciplinary action, including criminal prosecution under the Uniform Code of Military Justice, UCMJ, and local and state criminal laws. AFMAN 31-116, Air Force Motor Vehicle Traffic Supervision, applies to everyone with military installation driving privileges. If a member has a blood alcohol percentage of 0.05 but less than 0.08, the person is presumed to be impaired. This standard may be considered with other competent evidence in determining whether the person is under the influence of alcohol. There is a 1-year driving privilege suspension for driving or being in physical control of a motor vehicle while under the influence of intoxicating liquor 0.08% or greater. 20.15 Substance use or misuse. Department of Defense policy is to prevent and eliminate problematic substance use in the Department of Defense. Substance use and abuse is incompatible with Air Force core values, maintenance of high standards of behavior, performance, readiness, and the discipline necessary to accomplish the Air Force mission. Additionally, substance abuse and misuse can cause serious physical and mental health problems and jeopardize safety. According to AFI 1-1 Air Force standards, the illegal use of drugs or improper use of legal drugs is prohibited and will not be tolerated. In AFI 90-507, Military Drug Demand Reduction Program, drug abuse is described as the wrongful use, possession, distribution, or introduction onto a military installation or other property or facility under military supervision of a controlled substance, prescription medication, over-the-counter medication, or intoxicating substance other than alcohol. Wrongful means without legal justification or excuse and includes use contrary to the directions of the manufacturer or prescribing healthcare provider and use of any intoxicating substance not intended for human ingestion. Drug abuse also includes inhalant abuse, sometimes referred to as huffing, and steroid usage other than that specifically prescribed by a competent medical authority. Violators are subject to punitive action under the UCMJ and adverse administrative actions. The knowing use of any intoxicating substance other than the lawful use of alcohol, tobacco products, or prescription drugs, which is inhaled, injected, consumed, or introduced into the body in any manner to alter mood or function, is prohibited and will not be tolerated. The possession of an intoxicating substance with the intent to use in a manner that would alter mood or function without legal authorization is prohibited and will not be tolerated. Failure by military personnel to comply may be a violation of Article 92 UCMJ, resulting in a less than honorable discharge from military service and criminal prosecution under the UCMJ and local and state criminal laws. Note: Air Force members with substance abuse problems are encouraged to seek assistance from the unit commander, first sergeant, substance abuse counselor, or a military medical professional through the Alcohol and Drug Abuse Prevention and Treatment (ADAPT) program. ADAPT and drug demand reduction programs include substance use or misuse prevention, education, treatment, and urinalysis testing. Members are held to the highest standards of discipline and behavior both on and off duty. All patients diagnosed with a substance use disorder and entered into ADAPT will be recommended for limited duty, indicating the patient is not worldwide qualified. Individuals who experience problems related to substance use or misuse will receive counseling and treatment as needed. However, all Air Force members are held accountable for unacceptable behavior. Commander's identification. Unit commanders will refer all service members for assessment when substance use or misuse is suspected to be a contributing factor in any misconduct. Examples include driving under the influence, public intoxication, drunk and disorderly, spouse or child abuse and maltreatment, underage drinking, positive drug test, or when notified by medical personnel. Commanders who fail to comply with this requirement place the member at increased risk for developing severe substance problems and may jeopardize the safety of others and ultimately mission accomplishment. 20.16 Drug Testing. The Air Force conducts drug testing of personnel according to AFI 90-507 Military Drug Demand Reduction Program. Drug testing is an effective deterrent for the illegal use of drugs. Therefore, Air Force military members are subject to testing regardless of grade, status, or position. Military members may receive an order or may voluntarily consent to provide urine samples at any time. Military members who fail to comply with an order to provide a urine sample are subject to punitive action under the UCMJ. Note: commander-directed testing should only be used as a last resort because the results may not be used for disciplinary action under the UCMJ or to characterize an administrative discharge. Inspection under Military Rule of Evidence 313. In general, an inspection is an examination conducted as an incident of command, the primary purpose of which is to determine and ensure the security, military fitness, or good order and discipline of a unit, organization, or installation. Inspections may utilize any reasonable natural or technological aid and may be conducted with or without notice to those inspected. The positive result of a urine sample may be used to refer a member for a substance use evaluation, as evidence to support disciplinary action under the UCMJ or administrative discharge action, and as a consideration on the issue of characterization of discharge in administrative discharges. Probable cause. Probable cause requires a search and seizure authorization from the appropriate commander, military judge, or military magistrate to seize a urine specimen. Probable cause exists where there is a reasonable belief that drugs will be found in the system of the member to be tested. Results may be used as evidence to support disciplinary action under the UCMJ or administrative discharge action. Medical purposes. Results of any examination conducted for a valid medical purpose, including emergency medical treatment, periodic physical examination, and other such examinations necessary for diagnostic or treatment purposes, may be used to identify drug abusers. Results may be used as evidence to support disciplinary action under the UCMJ or administrative discharge action. Self-identification. Air Force members not currently under investigation or pending action with alcohol problems, substance use problems, personal drug use, or possession are encouraged to seek assistance from the unit commander, first sergeant, substance use counselor, or a military medical professional. Following an assessment, the ADAPT program manager will consult with the treatment team and determine an appropriate clinical course of action. Commanders may not use voluntary disclosure against a member in an action under the UCMJ or when weighing characterization of service in a separation.